The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain what happens if there's not a power of attorney and someone becomes mentally incompetent, and how that person's loved ones can make decisions for them. This basically involves a guardianship proceeding. But first, let's talk about what a power of attorney is. So a power of attorney comes in two flavors: a financial power of attorney and a healthcare power of attorney. And a power of attorney is something signed by someone who is mentally competent and understands what they're doing when signing the document, to provide for a time when they may no longer be mentally competent. So it's a pretty standard part of an estate plan. And what it will do is the financial power of attorney will name somebody to make financial and legal decisions, maintaining lawsuits, stuff like that, for the person who signs it, in the event that they're no longer able to do those things on their own. A healthcare power of attorney names someone to make healthcare and major life decisions if they're not able to do so. And in order for either one of these to be effective, you have to be certified by a doctor as being mentally incompetent. So what these do is they basically provide an automatic switch that once a doctor certifies you as mentally incompetent, it provides the person you name in your financial power of attorney and the person you name in your healthcare power of attorney with immediate powers to make decisions and act on your behalf to care for you. And this is really important because in the absence of a power of attorney that's signed while you're still mentally competent, if someone becomes mentally incompetent either through old age, accident, or disease, then in order to legally have the power to make major life decisions, healthcare decisions, where the person's going to live, manage accounts, investments, paying bills, stuff like that, in order to have that power, the person's loved ones have to be named their legal guardian. And this isn't something that's necessarily easy or cheap to do. In order to be named someone's legal guardian, you have to file a petition for guardianship in the guardianship court, and the court will basically hold the trial and hear evidence showing that the person has become mentally incompetent. And this usually involves expert witnesses, including doctors and psychologists, and it can include lay witnesses like family members. But you basically have to prove, one, that the person is mentally incompetent, and two, that the person that is petitioning for guardianship to be named the guardian is the appropriate person to be named a guardian. And there may be a guardian ad litem, basically an attorney appointed to look after the interest of the mentally incompetent person and do an investigation of the situation and submit a report to the court. So the whole process, we want to avoid it with powers of attorney if we can, because it can take anywhere from a month to 6 months, and if the person who's no longer competent doesn't really understand what's going on and contests it, it can take even longer than that. Or if the family members disagree as to who should make those decisions, there can be litigation over the subject, which could be avoided if someone had been named by the person who is now mentally incompetent in their power of attorney documents. So that's one reason we want to avoid it. Another reason is you've got to pay an attorney to maintain this suit and gather expert reports and hold the trial. Another reason we want to avoid it is that every year you have to go back into court if you're the guardian of this person and submit a report on how you managed their assets. So any income, any expenditures. And sometimes even if you're just a guardian that's appointed for the purposes of making life and health decisions and not financial decisions, the court may require you to come in and make an annual report, and this requires you to have an attorney help you prepare it. And that can be expensive, time-consuming, and a headache. So with a power of attorney, you avoid all of those headaches. Now, again, it's not the end of the world. If you don't have a power of attorney, having someone named as a guardian, it's supposed to facilitate the process. It's supposed to make it so that it's easy for someone to take action on your behalf. So it's a net positive. It's just a little bit more of an arduous route to get to that net positive, having that guardian named. So that's how it works. And once someone is named a guardian, then they actually have the power to make financial, legal decisions, healthcare, and decisions about where you're going to live, and there's some types of decisions that require court approval in order for the guardian to make them. So if you have any questions, you can leave them in the comment section below this post at learn-about-law.com or below the YouTube video on our YouTube station. If you found this helpful and you want to be informed with the topic of our daily article and video posts we make every day, you can subscribe to us on YouTube, iTunes, and SoundCloud, and that helps us. You can also submit your email on our website to be added to our email blast to get all of our content emailed to you. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations, and we have offices all around Chicagoland for your convenience. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.